What about cases where the court feels that there's just too great a risk to public safety or the criminal conduct as alleged is too egregious? Can the court consider those as reason to deny your diversion petition? Well, we don't really know. But here's what we do know. The California Court of Appeal decided in Wade versus Superior Court in 2019 that somebody applying for military diversion in a DUI case cannot be denied diversion because their BAC is too high or their driving is too bad. As you may know from other videos, diversion is a way to get a case dismissed where you don't have to admit fault, you don't have to plead no contest, you just agree to establish certain conditions over a period of time, and then based on that, the court agrees to simply dismiss the case like it never even happened. There are many ways to get your case through diversion. You may know from some of our other videos, if you're a former or current member of the military, you may be able to get diversion for a misdemeanor case through what is called military diversion. Another big statute that dropped a couple years ago is Penal Code Section 1001.95, which allows anyone facing a misdemeanor case or most misdemeanor cases to petition the court for a grant of diversion, even when the DA does not want to agree. And this is really important because the court can just order that diversion be granted in that case. You don't have to negotiate it with the DA. Now, 1001.95 requires a wide swath of misdemeanor cases considered for dismissal, be it theft, assault, even, believe it or not, vehicular manslaughter under California Penal Code Section 192. There's all sorts of cases that can be considered for dismissal under a grant of diversion and the court structuring a treatment plan. But the court seems to have a wide variety of discretion to say yes or no to a diversion motion. And if your case is denied for diversion under this section, what can you do? Well, look closely as to why the judge denied your diversion petition. One issue that I think comes up is, what is the court even allowed to consider? 1001.95 clearly states that some type of offenses are just not allowed to be considered for diversion. Domestic violence offenses, stalking offenses, and sex crimes that are registrable under Penal Code Section 290. They are just flat out, you cannot get diversion for it. And we've also learned over the last year or so that older statutes prohibit diversion under this section for DUIs. Military diversion allows for DUI diversion, but 1001.95, it does not. One thing you should know is talk to your lawyer about your case. If you're fighting a misdemeanor case that might be eligible for diversion, talk to your lawyer about whether there's a righteous fight for diversion under 1001.95. Even if your case seems really egregious, like there was a lot of contraband seized, there was a really bad injury, or a lot of stuff taken, even if all of those things are present, press your lawyer to say, what are my chances if we fought for diversion here? What is the judge like? What types of factors do they consider? And if they say no, what type of record did they leave? Could we find an appeal on this issue and go to a higher court to say, no, you denied diversion for impermissible factors? This is just like the Wade case where they used impermissible factors to deny diversion. Or will the court say, no, they used an acceptable amount of factors, and which ones are acceptable and not? Again, it might not be totally clear because 1001.95 is so young. But it's worth an argument, it's worth the research, and definitely it's something worth talking about with your lawyer when you're fighting a misdemeanor case. To watch the video about military diversion, click this link.